What are the types of trusts that are available for you? Hi, I'm Guy DiMartino. I am a Northwest Indiana probate lawyer and estate planning lawyer, and I would like to answer that question for you. So typically trust comes in two flavors, a living trust and a death trust or testamentary trust. So what that means is you can go ahead and you can prepare a trust while you're alive, and it comes, and that trust starts when you're alive, thus a living trust. You can also prepare a trust or have a trust prepared once you die, and the trust will go through the will, and that is a testamentary trust. Now, when we talk about living trusts, first, the trust is an agreement between the person who sets up the trust, and that person who sets up the trust is the grantor or trustor or settlor, and the trustee, the person who's going to manage the trust. Typically, if it is a probate avoidance trust, and that is a revocable living trust, that most of the time the trustee and the trustor are the same. So that's the first trust that we can talk about. Revocable living trust, typically a probate avoidance trust. And so irrevocable trusts can come in a number of flavors also, but typically when somebody prepares an irrevocable trust, they're doing it for either protect life insurance, so they can use life insurance if they're coming up against a federal estate and gift tax. They can set up an irrevocable trust for Medicaid planning, so the state will not get your assets if you have to go into a nursing home and accept Medicaid and have Medicaid pay for those things, or an asset protection trust. The typical view that you have to think about is if you set up a trust and you can get to the stuff in the trust, you can get to the property in the trust, then so can a creditor. So an irrevocable trust will protect your assets against creditor. The benefit of an irrevocable trust is that you can get asset protection or Medicaid protection if it was established within a certain time frame. The detriment in that trust is you are giving the ability to manage the trust to somebody else. Because if you could manage the trust, if you could amend the trust, then the trust is not an irrevocable trust. So we have revocable trust, we have irrevocable. And typically the third flavor of trust would be a special needs trust. Typically, special needs trusts are trusts that are set up to protect somebody with either a physical or mental disability, where if they go ahead and receive money, they will not lose whatever federal or state benefits they may receive. Now, special needs trusts also come in two flavors. The first is a first-party special needs trust, and the typical situation that we see those trusts coming in is you have somebody who is on Social Security income or SSI, or potentially Medicaid, or receive other types of state or federal benefits, and they're injured in an automobile accident, or they have some type of tort recovery, and because those programs are asset-based programs, they can fund a special needs trust so they do not lose their Medicaid or SNAP or SSI. Now, a third-party special needs trust is just what it is. That's a special needs trust that's set up by somebody else. It's not self-settled. So for instance, if a parent or a grandparent has a child or grandchild with some form of disability, and they're concerned that if they inherit money after the parent or grandparent passes away, that they will lose their benefits, you can set up a third-party special needs trust for the disabled person. So there you have it. Trusts come in many flavors, There's many different types of trust depending upon the situation. And so it's probably best that you speak with a lawyer in order to understand what they are and how you can meet whatever your goals are. If you have any questions, you can always reach out to me. I am Guy DiMartino. Have yourself a great day.